So many thanks for an extremely interesting set of reflections on present-day Ireland. A couple of reflections before we open it to discussion, Q&A, and bring in all the different issues we've talked about over the last day and a half. It strikes me that what Brian describes in this law in Ireland, which is removing or partially removing the privilege, the pre-penitentiary privilege in cases of sexual abuse, is also happening in the US. I think at least 6 states here have also changed the law on that and removed the privilege. So you could say limiting that dimension of religious freedom to make way for other perceived equally important or more important public policy objectives. And that shifting landscape of law and law protecting or not protecting religious freedom, it strikes me that Bill Nelson's analysis is very useful in thinking about those changing patterns over time, both what are the changing patterns of discrimination and, against minority religions or against religions in society at different times and places, but also the changing legal structures. When does the law embody either discriminatory practices itself, or when does it enshrine stronger protections, and that may partly, I think, but not totally, track these changing dimensions of power, socioeconomic power between different religious groups. So I think some intolerance is based on these factors of fear of loss of socioeconomic status. The discrimination against migrants, which we see very common in Europe today, is often based on a fear of the socioeconomic consequences of that, of jobs being lost and other kinds of changes. But some of it is based on just fear of the other, of prejudice, fear of difference. So I think both of these forces interact, but what's very interesting is seeing when the legal regime enters to either accommodate that kind of prejudice or even enshrine it, or to counter it through laws that protect various forms of religious freedom. So just a word on the European dimension, which we were going to cover in this session. Time is very short, but just to mention that there's an interesting parallel but difference between the European regime or legal regime and the US constitutional regime. If we think of the European Convention on Human Rights system, which is the overarching legal framework for 47 European states, as a kind of a loose analogy with the US constitutional framework, we heard in one of the earlier panels this afternoon that in the US the basic rule is one of neutrality. Neutrality is equality. All religions are treated in the same way, subject to the laws. And then there's a burden to establish, there's a possibility for exemption, religious exemption, where the neutral application of the law creates an excessive burden for that religious practice. Well, the structure of the law is slightly the other way around in Europe, though it does something very similar. In other words, it starts with the right to freedom of religion. That's what's articulated in the European Convention on Human Rights in Article 9. Everyone has the right to freedom of thought, conscience, and religion, including the freedom to change religion or belief, and freedom alone or in community with others, in public or in private, to manifest religious belief in worship, teaching, practice, and observance, as well as not to be compelled to either to practice religion or to express or to have to declare any religious affiliation. Then that's followed by a series of exceptions. In other words, the right is the basic principle, the right to exercise freedom. You don't have to argue for an exemption from a neutral application of the law. You start with the right to practice freely, but that can be limited. And then the grounds for limitation are fairly broad, at least broadly construed, such as are necessary in the interest of public safety, protection of public order, health, or morals, or for the protection of the rights and freedoms of others. And what we see I just had a look before today through the case law of the European Court of Human Rights on religious freedom over the last 10 or 15 years, and the kinds of cases coming up. There's an interesting selection of them, but they include cases. There's some on establishment of religion, some on taking still oaths for being required for public office, which identify the religious affiliation of the person taking office, and even that is considered to be a violation. But cases on dismissal by, we saw this, the ministerial privilege dismissal by religious organizations of employees whose practices or conduct is in some way not compliant with the articles of the faith. And in some of those cases, they're very nuanced. Some of them uphold the dismissal, some of them don't, because the behavior isn't closely enough linked to what's expected in relation to that religion. But the really dominant theme of religious discrimination law in Europe recently is around issues to do with the Muslim community, but to do with visible symbols, so the headscarf, veil wearing, various forms of religious dress, and now also a set of cases following on those cases to do with the crucifix and the and what we see is the case law does actually, if you look at it without looking at the legal argumentation, just at the outcomes, the states are allowed to restrict, states are permitted in many European countries, Turkey, France, Switzerland, Germany, to restrict the wearing of religious attire, religious dress that members of the faith consider is part of their religious duty. And so to that extent, we see no religious exemption, being permitted, that it's considered to be the states have good reasons, educational, there's a whole set of reasons given, and that states have the right to do that. And yet, when it comes to the cases involving the crucifix, we see that states, in a famous case involving Italy, are entitled to maintain the crucifix in public schools, regardless of the wishes of non-believers or those who consider that to be a form of proselytizing, so on. So it looks as though there isn't there's a differential treatment of different faiths depending on whether that faith is a minority religion or not in the state in question. So all of these issues are still very present, but they take a different shape. There are different groups involved, and I think it's very interesting how resonant the themes in People and Philip still are. And the very last theme, one I've already mentioned when I spoke earlier, is Walter's passion, which is cause lawyering. That I think that's another very interesting theme of the People. And I think Walter always describes Sampson as the first human rights cause lawyer, and now there are many, and it's a sort of a profession, a sub-branch of the legal profession, particularly in the US, but also in parts of Europe. So with that, let me open the floor to questions.
Well, I sort of have a general question. One thing that has come through on many of the examples in the discussions today is the fact that something which is a law which is facially neutral and which in fact may not have had any intended impact on religion may in fact impact on different religions differently, because simply there's more fit for the practices of some religion to agree with the customs of a country than for other religions in that country to do so. And this raises the question of whether we need to go to find some more fundamental principle than simply neutrality of the civil law with regard to religion, and in determining whether a law should in fact be imposed when it is in conflict with a religious principle.
Well, of course, what I think Leslie was mentioned in her presentation is, of course, the United States Supreme Court has said that is no longer what the standard is, of course, that you provide religious exemptions. But several states have passed what are called state religious freedom restoration acts that do impose a compelling interest standard for those types of situations of neutral laws of general applicability. It's hard to come up with a single standard for all situations, though, because then those become their own neutral laws to a certain extent. And the law in the pre-Smith era, before 1990, just recognized that these were kind of on a case-by-case basis, that there could be just some groups that a law would have disproportionate impact on, which 99% of us would not have a disproportionate impact on. And so it depended on the severity of the burden, and then, of course, the state's interest in maintaining some type of uniformity of the rule. But I think it would, at least would fly in the face of this whole sense of having some type of exemption for sincerely held religious belief if it had to be a kind of uniform thing that all other people participated in the same type of exemption. Once again, then that would become the law of general applicability and become almost a circular type pattern. So I think it's always going to be, for those who advocate that, these have to be case-by-case exceptions where you do need to show a significant burden, but then you provide the exemption for that particular individual, which may be unique to that one person.
This question of finding some solution in some way to this problem is perhaps misconceived. Reinhold Niebuhr once made a wonderful description of democracy. He said it was a set of proximate solutions to insoluble problems. And the point, I think it's applicable here. If you set up two clauses, as we have in the First Amendment, and you run them through a whole series of Supreme Courts and Supreme Court justices, and interpret them the way they do, you're inevitably going to get a serious problem, and the court's aware of it. I mean, this law is pretty much a shambles. And you put that, you add to that the context of American society and its changes, the kind of religious groups, the dynamic of religion in society that's changing. Put that stew together, and you have to simply say to yourself, look, if we're looking for some kind of consistency or some magic wand approach or philosophy, we're not going to find it. What we're going to do is what we're doing right now. We're going to muddle through with this. And we have to give up the idea that somehow we're going to find the magic grail.
There may be other answers to this because it's a wonderful question, but if I could just emphasize that the test which you have very clearly stated is the test which, since the 1990s, in cases Smith versus the United States, this is the one that involved peyote, which is a hallucinogenic cactus that Native Americans use for religious purposes, and the idea that a general law against the use of drugs could then catch that, and there would be, what Justice Scalia said in that case is that because it's a general and a neutral law, it's not an attack on religion, it's just a law that's achieving a social policy, that there is no possibility for a person to raise the First Amendment. So that is the test as it is stated now. It is the direct opposite of what happened in Phillips. Understand that what happened in Phillips is that the test which Sampson and his fellow lawyers proposed and which Judge Mayor Clinton adopted is one that says you begin with the idea that the rights of the individual to religious freedom is something which is prior to the state, if you like. And so making a religious objection to a civil law then flips the burden. What it does, as long as that's sincere, is it means that it is up to the state to prove that it has a compelling interest, which, as Steve has just said, is going to have to be, doesn't mean you win, but it means that it's up to the state to prove that it has no other way of achieving a legitimate social policy other than to deny you the exemption. Otherwise, you get the exemption, right? So that's the test. So this is contested history. It was while the other part of the First Amendment, the Establishment Clause, got quite a lot of scrutiny by historians over the years and by the Supreme Court. Oddly, this one didn't, and this case lay dormant in large degree, and this conference is a wonderful renaissance of it, if you like. But 150 years later, and this is only after the incorporation of the First Amendment and other things that happened, we've heard the impetus of the Holocaust made a big difference. Exactly 150 years later, in 1963, the same year of JFK's assassination, the Supreme Court addressed that question, and most constitutional lawyers understood them to adopt the Phillips test. Now, they didn't talk about any history, and they didn't cite Phillips, and I don't think they knew about Phillips, although they could have. There were sources they could have dug into, but they didn't, okay? So for a few decades, people went on the presumption that the compelling interest standard, meaning that if you show you have a religious burden, it's up to the state to prove a compelling interest, otherwise it must give you the exemption. That's effectively a restatement of the Phillips standard. It seemed to be in place until the Peyote case. In a case that followed the Peyote case, which was called Smith in 1990, another case which involved the Religious Freedom Restoration Act, because Congress reacted, this became a controversial decision. Justice Scalia did address the history, and he sparred with Justice O'Connor on it, and Justice Scalia brushed away Phillips because it stood in his way. He made the claim, which is actually inspired by a Notre Dame law professor, Gerard Bradley, and you can actually track the language in Justice Scalia's opinion, and you see he actually sort of borrows it, he kind of plagiarizes it. And he says that the only way to prove this would be to have a case that gave an exemption. And Bradley said, there is none. So he excluded Phillips, which he did know about. And because of this, Scalia said that Phillips is a lone case from a minor court and weak authority. Now, I think this conference shows the contrary. It was an extremely important case. It actually toppled the whole common law, which would have gone the other way in this country. It's the first victory for religious freedom in constitutional history generally, right? So my view is that Scalia was simply wrong on this, and that if it comes up again, and we'll see, but you know, the cases, the statutes we talked about, you know, these are ones where it could be argued. It's a very interesting question to ask how it would be decided. And I wonder how Scalia, for example, would decide a case where the legislature simply did not acknowledge this privilege. So it's a wonderful question, and it's contested history, and this is very live.